Hello again. My name is Frederik Harhoff. I'm the Professor Emeritus of International Law at the University of Southern Denmark in Odense. This session is devoted to an introduction to human rights, which is also an extremely important part of international law as such. As we set out in the beginning of the series of lectures here, individuals are in some respect also subjects of international law, direct subjects. And one of the places in which they are subjects of international law is exactly in relation to human rights, because every individual living on this planet is entitled to protection of his or her human rights. We have been through a lot of discussion about what human rights really entail and who they apply to. I think that at this moment, the world is perhaps slightly divided into several areas where we will say that there are some fundamental human rights that are applicable to each and every human living being on this planet. And then there are other rights that are more, let's say, democratic or terms up in groups. Human rights, thank you very much, for the individual, but what about groups of individuals? What about family rights? Are they important also? And of course they are. In huge parts of the world, family rights, for instance, are considered to be more important than individual human rights. So here you see there's a division about how exactly to define human rights. Can human rights be collective or can they be only individual? But this is a matter of discussion, and so I want you to just find out what the human rights are, and then from there on you will have to, on your own, determine whether you find that individual human rights are more important than, for instance, the right to participate in a democratic vote or something. Now, it all started out by the Declaration of Human Rights in 1945, after the United Nations were adopted. And the Declaration of Human Rights sets out a number of rights that are fairly similar to the number of human rights that were later on added or included into various human rights treaties. And since we are living in Europe, I would like to go through or just have a brief look into the European Convention of Human Rights from 1954. Article 2 of the European Convention on Human Rights reads, "Everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in execution of a sentence of a court following his conviction of a crime for which the penalty is provided by law." So you have the right to life, meaning that you cannot be killed lawfully unless, of course, it is a part of a killing that takes place in a lawful war. So there are exceptions to the right to life, namely for soldiers or people who are involved in an armed conflict. They are not only entitled, under some circumstances, they're even obliged to kill the enemy. So the laws of war and laws of armed conflict sometimes conflict with the human rights. And in that case, we say that if there is a conflict between a human right and a provision in the laws of war, then if there is a situation of armed conflict, then the lex specialis will prevail, that is to say, the law of armed conflict. So the right of life does not apply in an armed conflict, because that's the purpose of the whole thing, is to kill the enemy. So you can only do that lawfully under the laws of armed conflict, whereas under human rights, of course, you cannot. Then Article 3 says, "No one shall be subjected to torture or to inhuman or degrading treatment or punishment." I think this is a very fundamental rule. Most parts of the world will adhere to this and say, of course, torture is really not allowed. But again, what is torture? That is the infliction of severe pain on the person or the body of a victim. You know as well as I do that countries, several countries, including Western countries, have defended the right to use limited amount of violence against civilians or individuals in order to extract information, for instance. So, and that can be justified perhaps in so many ways. But the bottom line is torture is prohibited. So even if you use it for the purposes of extraction of evidence. And you know, the experience is that in most cases where we have used torture for the purpose of extracting evidence and information, it often turns out that the information you extract is unreliable because the victim is so scared that he will tell you anything just as long as you would stop the torture. So information extracted by the use of torture is often unreliable, and that is just an additional reason to drop the use of torture in any case. Article 4 reads, "No one shall be held in slavery." That goes without saying, but again, we have long traditions of using slaves also in our culture, and so I think we should make sure that slavery, also human slavery, human trafficking, in these our times is brought to an end. Article 5, everyone has the right to liberty and security of persons. Well, so you have the freedom to live the way you want, and you have the freedom to move around freely, unless, of course, you are detained or arrested for some lawful purpose. Article 5 has a number of provisions in it. Article 6 deals with the protection of lawful in the determination of his civil rights and obligations of any criminal charge against him. Everyone is entitled to a fair and public hearing with a reasonable time by an independent and impartial tribunal established by law. So the right to justice is also one of the fundamental aspects of human rights. Then you have the provision, Article 7, that no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a crime, a criminal offense under the national laws at the time when it was committed. That's the rule. And then it goes on, Article 8, everyone has the right to respect for his private life and family and his home and so on. And then everyone has the right to freedom of thought, conscience, and religion. You cannot take that away by law without violating the laws of human rights. We could go on, but what I want to say to you is that you have to, first of all, know what the human rights are in the European Human Rights Convention. You have to have a fairly good idea about what these provisions really cover and how far they extend. You also have to be, if I may conclude, you also have to be aware of the possibility of different interpretations in different parts of the world. And you'll be often surprised, as I did myself when I was working in the United Nations and had discussions with people coming from other cultures about just how differently we actually look upon human rights. So the way of treating human rights as purely individual is not something that is shared all over the world. On the contrary, I think many, or not most parts of the world, these rights are interpreted very differently. So there you have it. Make sure that you read the articles of the European Convention, that you understand them as far as you can, and always keep an eye open for different interpretations. Thank you, finally, for attending these lectures of international law. I hope you have enjoyed it, and certainly that you have picked up something useful which you hopefully will never forget and may be able to use in your future lives. Thank you so much, and good luck.